We at Pacific Legal Foundation like to say we are not a think tank, we're an action tank, an action organization. We're a public interest legal foundation that fights against big oppressive government. So we go to court every day, clear across the nation, to stand up for property rights, individual freedom, and constitutional principles. Our victories work at two different levels. Without charge, we protect our clients, average Americans who've been abused by government officials. And we win lasting precedent and help shape the law and strengthen the freedom of all Americans. Let me show you an example of what I mean.
John Rapanos wanted to build on his Michigan cornfield in the late 1980s. He never imagined it would cost him years of litigation and land him in federal prison. All this because he moved some sand on his own private property.
Well, let me tell you what this case is about. At one level, it's about federal power to regulate wetlands. At another level, it's really about civil rights. Pacific Legal Foundation is in this case to vindicate Mr. Rapanos' right to be free from illegal and heavy-handed federal regulation. We also hope to vindicate every citizen's right to be free from arbitrary government action. And we wish to affirm the bedrock constitutional principle that there are limits to federal power.
We are standing in what they say is a wetland. There's no fill here. We're standing in a cornfield, and you're facing what both in the criminal case and the civil case they say is wetlands, right here in front of us, from here to the Labadzinski drain, both the criminal and the civil case. And you can see here that this goes downhill into that county drain that was dug 100 years ago. And they accused me of digging that ditch. Well, when he was told, this expert for the government was told, Rapanos didn't dig that, that's a county drain, he said, well, then this couldn't be wetlands. And he was not allowed to come back the next day. The EPA fired him.
The federal government is saying that they can regulate anything that's connected hydrologically to a navigable water, a traditional navigable water, a water on which you could float a boat. If even one molecule, one drop, or a trickle of water flows from point A to a navigable water, it's subject to federal control. And in this case, we're talking about a trickle of water that's running from 20 miles away. And according to the federal government, according to some courts, it doesn't matter whether this a trickle of water is flowing over a foot or 100 miles. It's the same.
We're really looking at is federal jurisdiction. And when Congress passes laws, it's not up to federal bureaucrats or any kind of government employee to decide that they want to pursue the law in their own fashion. They're supposed to follow the intent of Congress.
On June 19, 2006, the Supreme Court of the United States ruled in favor of John Rapanos and the Pacific Legal Foundation.
This case was really about our constitutional way of life. The question we put to the Supreme Court was whether it was going to enforce a rule of law. The Supreme Court agreed with us that there have to be limits to federal authority, that the Constitution has to mean something. In this case, the Chief Justice, Justice Roberts, said this was another defeat for the federal agency that had a boundless interpretation of its own authority. The Supreme Court agreed with us that it's the federal government that acted illegally, not Mr. Rapanos.
They do pick targets, because we discovered in my case, by going through documents, that I was targeted in Michigan. And they target people who are large developers, or large farmers, or the elderly farmers who really are trying to save their nest egg for their children and grandchildren and their old age. They go after vulnerable people.
We often get involved in cases as a friend of the court, and we offered our services to Mr. Rapanos to support him as he appealed his case. As it turned out, he couldn't afford to pay for private counsel, and so he asked if we'd be willing to take his case to the Supreme Court. because of the importance of the case, we were happy to do so.
What I've discovered is a couple, 3 or 4 egregious situations. One is a property in the Thumb area. The people who own that, it's a sod farm, and it's been in business for 50, 60 years. And these people are becoming elderly, and the government has shut them down. They've been fighting about it. They want to exact all kinds of fees and permit fees and fines against them and all of that. And then there's also a cranberry farmer that I've been reading about, where it's just insane because they want to charge him thousands, hundreds of thousands of dollars for permits to farm on their own property. I mean, these people have farmed on these properties for 50, 60 years. And the government comes in now and says, oh, tough luck.
Charlie Johnson and his son Van are cranberry growers in Massachusetts. When their cranberries are mature, the Johnsons flood their fields and skim the cranberries. The EPA and the Army Corps of Engineers claim they're creating wetlands and need a federal permit to harvest their crop. They want to charge the Johnsons $70,000 for that permit.
Our lives have been at a standstill for 10 years. We cannot borrow a dime. If you go to a bank to borrow money, the first thing they ask you is if you're party to any litigation, and obviously we are. And to be in litigation with the government, particularly the EPA, is probably the worst thing that you could be doing. So anyway, here we sit today. Very happy that Pacific Legal has saved us. I have no conception of where we might be. We've pretty much, my son and I both, pretty much decided that we are not giving an inch. We will give them not a nickel. We will remove not a shovelful of dirt. We've done nothing wrong, ecologically and otherwise, and we have any amount of expert testimony that backs up our position. It's gone way beyond anything. I don't even think, as far as the government's concerned anymore, that the environment is the issue. It's strictly an issue of perpetuating a bureaucracy to not knowing how to gracefully concede that you might, for that matter, be wrong.
What the Pacific Legal Foundation has done for me and my family, I can never repay. I mean, no matter what, I owe so much to those people that I'm indebted to them for the rest of my life.
PLF is in the business of rescuing liberty from an overreaching abuse of government, and we see that every day. We have individuals coming to Pacific Legal Foundation on a daily basis asking for us to take their cases on because they have been abused by government overregulation and by bureaucrats who are overreaching their authority. So we seek to find the right cases, represent the right clients, and the right clients are those folks who have the courage to go as far as it takes to try to establish legal precedent. Believe me, it takes real courage for a client to do that, because sometimes takes 4, 5, 6, 7 years to get a final resolution of a case, and that can be very costly to an individual. We find those individuals, they come to us, or we find them, and we hope that we can eventually resolve the case, not only for them, but for society as a whole, create that legal precedent that is going to protect the individual and economic freedom of folks in this country, and definitely promote their private property rights.
And now, some final comments from PLF President Rob Rivett.
Pacific Legal Foundation is able to represent people like John Rapanos and the Johnsons for one reason only: you. Generous people like you make it possible for Pacific Legal Foundation to go to court to rescue liberty from the grasp of government power. For that we thank you.